You're watching The Legal Breakdown. So, Glenn, Trump has now asked Judge Chutkan to recuse herself from presiding over his election theft case in Washington, D.C. She's now responded to his request. Can you go over what happened here?
Yeah, Judge Chutkan will be presiding over Donald Trump's trial in Washington, D.C. for his attempt to overturn the results of the 2020 election because the judge pretty easily and definitively denied Trump's motion to have her recuse herself, have her remove herself from the case. And when you read the pleading that Donald Trump's lawyers filed with her, trying to convince her that there was some basis to have her remove herself from the case, it really read like a combination of an extended tweet and a campaign ad. Brian, I continue to marvel at how all of the lawyers that sort of undertake to represent Donald Trump immediately seem to stoop to his level, such that they are filing, pleadings and motions in court that are an embarrassment. They're a joke. So here's what the lawyers said. They said to Judge Chutkan, well, while you were presiding over other January 6 cases, when you were trying other cases, when you were sentencing other January 6 defendants, people who attacked the Capitol, you said certain things about Donald Trump. And those things you said really didn't paint Donald Trump in the most flattering light. Therefore, you can't be a fair judge presiding over Donald Trump's trial. Well, for openers, that's kind of absurd. But if you dig down and you look at the law of recusal, here's the thing. There are two dramatically different kinds of statements that a judge can make: extrajudicial statements and intrajudicial statements, legal mumbo jumbo. All that means is that when judges make extrajudicial statements, meaning statements outside of court, when they're giving speeches or they're talking about something in a setting other than being in court handling a case, if they start to say things that make it seem like they have some kind of a bias against somebody, that could be a real problem. That could lead to the judge having to recuse themselves from the case. But when you're making intrajudicial statements, when you are talking about the very case over which you are presiding, which is what Judge Chutkan was doing, those statements rarely are going to be enough to have a judge recuse herself from the case. And even more pointedly here, what Judge Chutkan was doing was talking about the arguments that these J6 defendants were making. The arguments they were making were fact-based arguments. They said, hey, I'm not as guilty as Donald Trump. Donald Trump is more guilty because he ordered the attack on the Capitol. I was just following orders. But you know what? He hasn't been held accountable. He hasn't been charged with anything. This was before Donald Trump was indicted. So therefore, I am deserving of less punishment than Donald Trump. So what she did, as she is obligated to do, I'm turning this into a crim law class, is when a judge is presented with those kind of arguments, the judge has to acknowledge them, has to comment on them, and then has to say why she either agrees with them or she disagrees with them before she imposes sentence. And that is all Judge Chutkan did. She didn't say anything inappropriate. She didn't do anything appropriate. Most importantly, she demonstrated absolutely no bias against Donald Trump. The defense, on the other hand, would pick and choose a word here and a sentence there and try to string them together out of context. And Judge Chutkan's 20-page ruling and her order made all of that clear. And so she refused to remove herself from the case. And that is an absolutely bulletproof ruling as far as I can see, based on the rationale that she put in that 20-page order.
To that point on whether it's bulletproof, does Trump have the opportunity to seek her removal from the case by appealing to a federal circuit court now? And is that something that he might try to do?
Yeah, that's a good question. So he doesn't have a right to appeal this decision. Ordinarily in a criminal case, and this is good news because we've seen Donald Trump involved in civil cases where he seems to appeal every ruling, really just to weaponize the delay built into the system.
Right.
Well, in a criminal case, you can ordinarily only appeal after the trial is over, after you've been sentenced. That is the time to appeal all of the issues that you disagreed with that unfolded during the course of the trial. So he doesn't have a right to an immediate appeal of this. He does have he does have the ability to file what's called a petition for a writ of mandamus. Again, legal mumbo jumbo. It's an extraordinary writ. It's something that's rarely filed and even more rarely granted by an appellate court. But here's what it is. If a judge essentially violates the law, more precisely, if the judge departs from a clearly established legal duty, does something that is so far out of bounds that there's really no legal authority for it, well, then a defendant can file for this extraordinary relief, asking the appellate court to basically direct the judge to do her job because she did something she had no legal right to do. That writ is available. He can try to file it, but here's the good news, Brian. If he does, it will involve pretty much zero delay because it is not a meritorious writ or appeal, and the appellate court would almost certainly instantly and summarily reject it. So this is one where Donald Trump really can't weaponize the delay.
Okay. Now, Jack Smith specifically opted not to ask Judge Cannon down in Florida to recuse herself because it may have colored how she would rule, how she would go on to rule on that case. Does this here in D.C., does this create a hostile environment for Trump now that he basically fired a shot across the bow at Judge Chutkan?
I think the answer is no, because knowing Judge Chutkan as I do, I used to try murder cases against her. She was a defense attorney. I was the prosecutor. She won't hold this against him. You know why? Because she's a good, honorable, ethical judge. You do not hold against a party, whether it's the defense or the prosecutor, a motion that they filed that is just surely a losing motion, not a strong motion, even if it's not a good faith motion. You decide the motion, and then you are back on that level playing field, and you continue to treat all parties fairly. So, no, this will have no impact on the way she rules moving forward. She won't hold a grudge, and she certainly won't hold it against Donald Trump. Here's the other thing. With respect to Judge Cannon, I think Jack Smith could have filed a motion to have her recuse herself. Why? Because unlike Judge Chutkan, where there was no basis for a recusal, Judge Cannon had an established record of violating her judicial discretion in order to do a huge favor for Donald Trump. Don't take my word for it. That is what the 11th Circuit Court of Appeals ruled. So I think Jack Smith could have done it. But here's the thing. I don't think Jack Smith declined to file the motion for fear that Judge Cannon would hold it against Jack Smith or his team of prosecutors. I think he looked at the issue. He assessed that maybe there's not quite enough evidence to support a motion to recuse. And that is why he likely declined to ask Judge Cannon to remove herself from the case. At least that's my take on what was motivating Jack Smith.
So I want to pivot here to a different Trump trial and some more news that we have. This is in the New York Attorney General's case. An appeals court just rejected Trump's request to delay that trial in the wake of the fraud ruling. So I think people are going to be a little bit confused here because the judge ruled against him. So what is Trump even trying to delay here?
Yeah, good question. This is a confusing one. So if we unravel it, we just had a blockbuster ruling by Judge Arthur Engoron up in New York in the civil case that was brought by Attorney General Tish James, basically trying to hold Donald Trump and his family and his chief financial officer and his organization, Trump Org, accountable for long-term rampant fraud at the expense of the New York taxpayers. And Judge Engoron just granted what's called a summary judgment motion. What does that mean? That means part of the case that was brought by Tish James was so strong and so conclusive regarding the proof of fraud that there was no need for a trial. There was no issue of fact to be resolved. So he basically directed a partial verdict in favor of Tish James. And it was a big one because it was a verdict that came with Judge Engoron ordering the dissolution, his word, of Donald Trump's companies, his LLCs. Basically, he is ordering the dissolution of Trump Org. He also held a bunch of Donald Trump's lawyers liable for sanctions, money sanctions. So, and he also canceled Donald Trump's business certificates. I mean, this is basically the end of Donald Trump as businessman in New York. It was a dramatic ruling. However, there are still some other issues that do need to be resolved in a trial. So this was only one count. I believe there are another 5 or 6 counts still to be resolved. And then there's the big issue of how much Donald Trump should be made to pay, because A.G. James brought the suit against him seeking at a minimum $250 million. And the amount he may have to pay is still an open question. So that's why the case has been partially resolved, but there are still some more issues to be tackled in a trial.
Now, in that trial specifically, the witness list includes Alan Weisselberg, Michael Cohen, Ivanka Trump, Eric Trump, Don Jr., and Donald Trump himself. Does that mean that we're going to see these people testify?
Yeah, the answer is maybe. So, Tish James put all of those names in the mix as possible trial witnesses. She may call some of them, but not all of them. If she calls some of them, they may have a Fifth Amendment right against self-incrimination and decline to testify. She may end up using some of their deposition testimony in lieu of trial testimony. So it's a mixed bag. We won't know who will actually testify until you hear, the prosecutors in the case announce that, the next witness being called for the state of New York is, for example, Donald Trump Jr. That's when we know Donald Trump Jr. will be called as a witness to testify.
Glenn, is there any scenario where you would imagine it would be smart for Trump's lawyers to allow Trump or his kids, who would otherwise be very hostile witnesses, to actually testify in this trial?
None. Other than perhaps Ivanka. Why do I say that? Remember, she was actually culled out of the litigation. She successfully filed a motion with the court to get herself removed from the litigation, and I believe there is no longer a civil case pending against her. That can be read in a couple of ways. Maybe she began cooperating with Tish James. Maybe there wasn't enough evidence to pursue the civil suit against her. It's an interesting development, but I would say if any of the Trump family members end up testifying, the most likely one would be Ivanka.
And could she be compelled to testify, or would that have to be voluntary?
She could be subpoenaed. You can be subpoenaed to testify. But in a civil case, you can certainly invoke your Fifth Amendment right against self-incrimination in the event she thinks her truthful testimony could possibly incriminate her, could be a link in the chain of proving that she committed some sort of a financial crime as part of the Trump organization. So again, all of these questions, will really only be concretely answered when we see that trial unfold.
Okay. Obviously, we'll stay on top of that as soon as we have any movement on that trial, as well as the raft of other trials that we're contending with right now. So if you want to stay on top of this stuff, make sure to subscribe. The links are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.